Good morning, everyone, and thank you so much for joining us for today's webinar, Professional Responsibility Under Municipal Renoviction Bylaws. My name is Claire Hepburn. I'm the Deputy Registrar at the OAA. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and are deeply connected to its rich cultural and natural landscape. I'd like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. So before we begin the webinar today, I just want to share a few housekeeping items with you. We will be recording the session today for quality and educational purposes. To maintain a stable internet connection, we have muted all your microphones and disabled video feeds. However, we do encourage your participation through the Q&A window that you'll see at the bottom of your screen. So at any point during the presentation today, if you have questions for our speaker, please enter those and they will be handled at the designated Q&A period towards the end of the presentation. If you're seeking continuing education hours, note that you will have to attend a minimum of 80% of today's webinar for those hours to be accredited to your transcript. Just allow us a few weeks while we upload and process those hours. And we do provide closed captioning services available in multiple languages. Finally, our presenter today does not provide insurance, legal, or practice advice, and the OAA does not bear responsibility for errors or omissions in discussions during the webinar. And finally, I am very excited to introduce today's speaker. Please welcome Ben Ries. Ben, over to you.
Thank you. Happy to be here and honored actually for the chance to discuss a topic that might be new, at least new to architects and engineers, but really is the culmination of quite a few years of work among tenant advocates, and I think it's a cool opportunity to sort of connect the role that architecture professionals will be playing with respect to these new renoviction bylaws with I think the history and the context that leads into it. So today, just to give you an overview of what I'd like to cover, we'll begin with just vacancy decontrol, no-fault evictions, and a broader understanding of how evictions for extensive renovations or repairs fit into the overall context for residential tenancy law in Ontario, the law that really protects and determines whether people who rent the housing that they live in get to stay there and what kind of rights they have. Because that, as you'll see, as we'll get to, is a crucial background to thinking about this qualified person role that has been created out of municipal renoviction bylaws that have been adopted in Hamilton, Toronto, and actually also London, Ontario, and I believe under consideration in Ottawa and a number of other municipalities across the province. Very similar bylaws that we'll look at that give architects and engineers a pretty critical role in helping to decide whether or not tenants should be evicted temporarily to allow this work to proceed. And then we'll try to connect that with your code of ethics and professional misconduct regulations to think about, what sort of factors should be front of mind when you're asked to provide one of these qualified person letters or reports. I'd like us to begin with a little poll. If Shalika, if you could fire up the first poll, that'd be great. Have you ever advised a homeowner on whether it's necessary for them to move out during extensive renovations or repairs to their principal residence? Is the question, and I imagine we'll get a mixed response. So with very much experience running Zoom polls, Shalika, do I have to do anything on my end, or do I just wait for you to close the poll?
No, she'll close it when we
Okay.
can see the numbers coming in, and it looks like about 75%. Okay.
Oh, okay, interesting.
Yeah.
So a real division, because and that makes sense to me. I mean, as a non-architect, I would think, first of all, you may or may not even work in that area of residential renovation or repair. I imagine also there's a number of renovations and repairs that homeowners make where they never have need to consult, or never think they have need to consult with an architect. But this is an interesting array of responses, people in all categories. So thank you. That's a result we'll keep in mind as we get onto this sort of question that we think architects can answer rather than municipalities. So in Ontario, you've got this framework for residential tenancies that some of you will be more or less familiar with, depending on whether you've rented recently, whether you've got family members who've rented. Most tenants know some things about what we're going to discuss, but we'll just try to provide, like, in a nutshell, an overview of residential tenancies law as quickly as we can. So there's really these three, I think, interlocking features, or big kind of ticket items for how the Residential Tenancies Act in Ontario works. The Residential Tenancies Act, of course, replaces very similar legislation from the 90s called the Tenant Protection Act, which itself replaced very similar legislation called the Landlord and Tenant Act 1970. So we're talking about core pieces of Ontario law that have really been more or less the same for about 55 years, with tweaks and changes around the edges. But these core concepts are actually pretty old now, at least to my way of thinking. There's standard terms. So the Residential Tenancies Act lays out a number of rights and responsibilities for landlords and tenants, and does not allow very much flexibility for landlords and tenants to contract out of those rights. So the ways that a person can be evicted, the things that a landlord can be responsible for, those are all laid out in the legislation. There are lists and there are forms at the Landlord and Tenant Board that correspond to those provisions in legislation. And it makes what the landlord and tenant have specifically agreed to in their lease agreement often irrelevant, or we would say void, if it's inconsistent with that system of rights and responsibilities. And what we'll be talking about today, of course, is the fixed list of ways that a tenancy can be brought to an end, ways that a tenant can be evicted. There's no creation of new types of evictions in a lease. Security of tenure is the other big one, which is sort of interrelated. So I would suggest it would be difficult to have any of these three components without the others. They sort of all work together and are mutually supporting. Security of tenure is this feature that we have not only in Ontario, but British Columbia, Manitoba, Quebec, and Prince Edward Island, where any lease that a tenant enters with a landlord, unless it's brought to an end under the legislation, under one of those fixed list of grounds of termination, it is automatically renewed by the statute. It keeps going. And most of us know this as going month to month, right? You sign your 1-year lease, and then at the end of the lease, if the tenant's still there and they're still abiding by their legal responsibilities, then it's going to continue. They're just going to continue paying, usually on a monthly basis, and they're going to continue living there indefinitely, sort of with the same kind of security or a similar security that a homeowner might have in their residence. Finally, rent control, right? A limit on how often rent can be increased, and the amount by which rent can be increased, with notable exceptions. So we'll just go through each of these in a little more detail. First of all, security of tenure. If we think about the way this works, in more detail, you sign your lease, and the lease has both a term and has a period. The period is the frequency with which rent is paid, and then at the end of the term, the statute says, okay, it's as though, let's just pretend that the parties have signed another 1-year lease, and at the end of that month, or sorry, another 1-month lease, I should say, and then let's pretend again. And this virtual renewal of leases is something that you might have seen recently in the news. Last week, the provincial government floated this idea that that there was maybe a problem with so-called evergreen tenancies or evergreen leases, and that the province might want to explore moving us to a model that is used in Alberta, Saskatchewan, New Brunswick, and Nova Scotia, where at the end of a fixed term lease, you got to go. And thinking about this as being very integrated with rent control and the other rules in the legislation for landlords and tenants, it doesn't require a whole lot of imagination. So you can think about, for example, if a tenant has a complaint or if a landlord tries to impose a rule that is outside of the legislation, and the tenant wants to dispute that, it matters quite a bit whether or not the landlord will then just have the option for any reason they want to not renew the lease at the end of the year, right? If your landlord can just say, well, I'm not interested in renewing, then as we'll see when we discuss rent control, they can increase the rent to whatever they want for the next tenant, and also a lot of tenant rights, and it kind of blows out the whole idea of having only limited types of evictions. Limited types of evictions, if we'll just talk about what they are in Ontario, and it doesn't vary a whole lot from province to province. We've got a number of so-called fault-based evictions, so evictions that are because of something the tenant is accused of. The most common one, the one that takes up the majority of the work at the landlord-tenant board, is eviction for non-payment of rent, or the N4, really tied into rent control and affordability and the cost of housing. A number of other types of eviction I've got listed on this slide, and then there are certain types that you can only get at the end of your 1-year lease or 1 year month to month. And those would be not only the tenant's unilateral notice, like I'm given my 60 days notice and I'm leaving, which a tenant can do for any reason outside of their fixed term, but also these so-called no fault evictions, the N12, landlords and purchasers own use. So landlord saying, I or a member of my family or my parents or my kid wants to move in to this property, or the N13 for renovation, demolition, or conversion. And there are specific rules, conditions attached to how each of those grounds work. We're zeroing in on renovation today, which people have taken to calling renoviction. It's kind of like a mashup term that I think is a little bit catchy and hard to get away from. But you see, I've put the beginning of the N13 form on the slide there. I don't know if my head is in the way of it, but that there are kind of further requirements that a landlord has to meet that we'll get into with respect to how they make out that ground of eviction and ultimately get an eviction order. But first, just casting our eyes over different models of rent control that are in existence, because those, it turns out, have quite a bit to do with renoviction. Okay, so the people who usually don't have to worry about this sort of this ground of eviction are those in rent geared to income or social housing. Their rent would be tied to their household income. It would go up and down. And in large redevelopments that, for example, Toronto Community Housing has done, for those of you in Toronto, you'll know that Regent Park, Alexandra Park, a number of other sort of large legacy social housing projects have been extensively redeveloped by the city. That's involved tenants being moved out, but usually the social housing provider takes care of a system that doesn't quite involve eviction. It involves transferring the tenants to other buildings and then maybe eventually transferring them back to the replacement building. So that's not really what we're here to talk about, because that's done in generally a more friendly and less profit-seeking manner. What we had until the late 90s was full rent control, which I think is only really left in Prince Edward Island at this point. But Ontario had it, and it meant that the rent was capped and the rent increases were capped for each unit, regardless of whether a tenant moved in or moved out. There was a database down at Queen's Park of all of the rents that could be charged for every apartment in Ontario, every basement unit, every duplex. There was a rent and there was a maximum that it could increase each year. That changes the incentive mix for landlords quite a bit. That has been moved over to what we've got now for most units, which is vacancy decontrol. So under vacancy decontrol, the rent is quote unquote market rent. It's whatever whatever the parties agree on at the outset of the lease. So when a tenant moves in, the rent is set between them and the landlord. All they really have to bargain over is what utilities and services are included in the rent, who's the landlord, who are the tenants, and then how often is rent going to be paid, usually monthly, when, usually on the first of the month, although it varies. And then after that, as long as the tenancy continues, the rent can only be increased once a year. There's a guideline cap on those rent increases that's inflationary, or it's inflation-based, and it's published once a year. There's a process for landlords to seek above guideline increases. There's a process for municipalities to decrease rent based on major tax reductions and that sort of thing. There are lots of sort of technical processes related to fiddling around with the rent, but in the normal case, the rent goes up by the landlord giving this notice each year to the tenant. And if the tenant ever moves out and the tenancy ever ends for any reason, then the landlord gets to look at a new tenant and reset the rent. And most of the time, and over most of my career, market rents, those rents that are being set, or sometimes we call them asking rents, tend to be quite a bit higher than actual average rents, or than the rent that people pay as a result of these increases. And that's because we've seen higher inflation in rents than the general rate of inflation in the rest of the economy. Housing prices, as most of us know, real estate prices, and with them rents, have all gone up, and they've continued to climb for the most part, well beyond what anyone's controlled rent would be. And so as a result, again, just for anybody who hasn't thought about this or isn't aware of this, the longer a person's tenancy is, the longer a person remains in their tenancy, the lower their rent will be compared to the market average for the same unit. And for the tenant, at least, the greater the stakes may be in terms of what might be involved in eviction. And that's where legal clinics like mine have focused more and more of our attention. So just, by quick deviation, if we think about this in human terms, a senior citizen in Canada living alone who doesn't have retirement savings is going to receive at most about $1,800 a month in old age security, Canada Pension Plan, and guaranteed income supplement. That $1,800 a month, for lots of seniors and older adults living right here where I am in South Etobicoke, might be paying for a $1,000 a month apartment, or a $1,200 a month apartment, or maybe even a $1,500 a month apartment, with less and less left over. And then, that kind of prospect of being evicted, say because the property is sold and the landlord's son wants to move in, let's say because the landlord wants to convert the property or demolish the property and redevelop it, any number of no-fault evictions, let alone what the tenant might face as a result of their own actions, would immediately confront them with average rents for similar units, $2,200, $2,300, and so on. And so for a lot of seniors, they just don't have the income to support that. We have a growing, population of people who, if evicted, would just experience a radical change to their life circumstances, and in some cases, unfortunately, homelessness. So this is, I want to drive home, make clear to everybody listening that when we talk about any kind of eviction, as it relates to rent control in the province of Ontario, for some people, in some cases, we are talking about homelessness and the risk of homelessness. In the very least, we're talking about whether people get to continue to be a part of a community, whether people get to continue to live with their entire family or live independently. I mean, regardless of who you're talking about or your perspective, there's a lot at stake. I think is the point I'm trying to drive home here. And then, of course, for units built after 2018, November 2018, the province has a new construction exemption. So those units are not subject to any kind of guideline cap on rent increases. The landlord can only increase the rent once a year, but it can be for whatever amount the landlord wants. And in some cases, we've seen rent increases of $300, $400, $500 a month. Real different kind of risk, I think, for the tenants living in those tenancies. They may not. I lived in a tenancy that was subject to a previous version of this exemption, and I never bought curtains that fit the windows because I thought, why? I could just be evicted, any year now, or I could face a rent increase that I'm not going to be able to pay. So that's also not particularly what we're talking about here, because what should be somewhat clear, maybe it's not clear, maybe we have to spell it out, is that if a landlord wants a tenant out and they are in a post-2018 unit, and the landlord is looking at no-fault evictions, which, remember, can only happen outside of a one-year term or when a tenant is month to month. If the landlord is willing to wait until the end of the initial lease, they could go through a complicated eviction process, no-fault eviction process at the landlord tenant board, or they can just impose a rent increase that the tenant can't pay. And then that'll generally bring the tenancy to an end a lot faster. So the only times that landlords would typically need to initiate a rent eviction process are for long-term tenants who might continue to be long-term. And that's going to be tenants covered by vacancy decontrol in most cases. I think we'll have plenty of time for questions at the end, but if they occur to you now, I think there's a Q&A function on Zoom, so either type them out or hold them until the end of the presentation, but I think it'll be easier to address them all at once. Thank you. So let's see. In summary, no-fault evictions are special, okay? So first of all, the principle of security of tenure, we said, like in general terms, is that as long as you follow the rules, you can stay and pay your rent, you can stay in your apartment. But that's not true if the ground of eviction has nothing to do with anything the tenant has done and is all about the landlord's plans. That's different. It's a different type of rule. It's a different type of risk for the tenant. It's a different type of litigation process, quite frankly. As a result, and connected with the move to vacancy decontrol, they're vulnerable to abuse. Because if you have a perfectly angelic tenant, let's say, who never bothers anybody and never damages anything and always pays their rent right on time, the landlord may still, over time, have a profit opportunity if they can move that tenant out and re-rent the unit to someone else. And it quickly becomes the case that one of the only ways to get there is for the landlord to go through a no-fault eviction. No-fault evictions, I should have said, if we think about them, landlord's own use, purchase own use, eviction for demolition or for conversion to non-residential use, so you want to turn it into a storefront in a mixed zoning area, the thing they all have in common is this idea that, well, the landlord is no longer going to be renting to anybody else. So this introduces this concept of an eviction in bad faith, right? If a landlord says that they want to essentially take the unit off the residential rental market and that's why the tenant has to leave, but it turns out that they had different ideas or different plans than what they said in the eviction notice, that's called an eviction in bad faith, and there are kind of limited regulatory responses or options for tenants that we may get into time permitting, and they end up being tied into this idea of rent eviction. Eviction for extensive repair or renovations, though, doesn't take the unit off the market, right? It only takes the unit off the market temporarily. And so, as we'll get into in a moment, that is the type of an even more special type of no-fault eviction, if you like, because there's a regime for this idea of the right of first refusal. And I'll say the other thing that a lot of these, but before we get into that, I'll say the other thing that a lot of these no-fault evictions have in common is that the Landlord and Tenant Board isn't the only authority that needs to be involved, okay? I guess with a eviction for purchase zone use, it's real estate agents generally who are involved, and they prove that the unit really has been sold. But for all of the N13 grounds, the renovation, demolition, conversion, the law requires that the Landlord and Tenant Board make the landlord produce evidence that they've applied for any necessary municipal permits. And as all of you would know, you're not demolishing a building or converting it to non-residential use or doing extensive renovations and repairs, typically, unless you're applying for a permit under either the building code and or the planning act, right? Like you're looking at, in some cases, official plan amendments, zoning bylaw amendments, in the very least, building permits. So looking to see that the landlord has either obtained or made best efforts to obtain those kinds of municipal permits is a kind of delegated authority, something that the Landlord and Tenant Board relies on municipalities to do the legwork on. We'll talk about how those work ideally, or according to the legislation, now with respect to renovictions, or as the legislation calls them, termination for extensive renovation and repair. So the landlord applies for those permits, right? It's actually, I don't think the legislation really conceives of a type of work that could require the tenant to move out while the work is taking place, unless it also requires some kind of building permit. That's kind of intuitive, although I'd invite anyone to think of something that you don't need a building permit for, but also is so extensive that the tenant needs to move out. And the landlord applies for those permits, and they serve an N13 notice, which the N13 notice is a 120-day notice. So there's a lengthy period that the tenant receives at the beginning when they get that notice, and sometime before the end of that notice period, what we call the termination date, the landlord is going to have to pay under the provincial legislation either 1 month's rent or 3 months' rent, depending on whether there are more or less than 5 rental units in the building. Okay, so so-called small landlords aren't paying very much to the tenant in compensation, and then the tenant either moves out voluntarily or they stick around because they're not able to move, or they're not sure that the landlord is acting in good faith. It really can be for any reason. And then the landlord would file an eviction application based on the notice that they've served, okay? And the eviction application leads to a hearing at the Landlord and Tenant Board between the landlord and the tenant, where the landlord is the one who's going to have to prove their case. They're going to have to prove, as we'll see, a number of legislative requirements have been met in order to get the eviction. The questions that the Landlord and Tenant Board are going to look at is, was the notice formally valid? Like, was it filled out properly by the landlord? Was it actually served on the tenant? Was the required compensation paid? How many units are in the building? Right, like they're looking for evidence of payment. Does the landlord have good faith intent to actually do the proposed work? Actually, sorry, I should follow this sort of snake line I've made here. First, has the landlord actually taken all reasonable steps to obtain required municipal approvals? Have they applied for building permits, or have they obtained them? And of course, the more the backlog at the Landlord and Tenant Board has made it so you don't just apply and get a hearing next month, the more and more likely it is that if you've applied for permits, you've got them by the time you get to a hearing, an eviction hearing. That is the landlord. And then this question, does the proposed repair or renovation require vacant possession? That question in the middle of this slide is actually the big question that is now being kicked over to architects and engineers under municipal renoviction bylaws. So that's what we're going to circle back to pretty hard. And I'll just comment maybe editorially as a person who represents tenants, me and my colleagues at the Landlord and Tenant Board, often defending evictions, that's a question that Landlord and Tenant Board members often struggle with. I think it's a question that you might struggle with, or at least I do, because for reasons we'll get into, fully moving out in order for work to take place is something that often depends on the way the work is done, and also on the tenant's tolerance level. And in many cases, unfortunately, the Landlord and Tenant Board members have started to conflate the issuance of municipal building permits with the need for vacant possession. So at one time, some municipalities would write on the permit, vacant possession required, and that would be an easy rubber stamp for the Landlord and Tenant Board to say, oh, okay, like somebody who knows more about this than we do has looked at the work that's going to be done and thinks that the unit needs to be clear. But municipalities, particularly Toronto, where I work, don't often answer that question at all. And could speculate on the reasons why, but just anecdotally knowing homeowners who live through or decide to live through major renovations inside their own home, there's maybe just been a growth in the range of work that people are willing to live through, and the city has decided that's not really their business. That kind of kicks this hot potato or tosses this hot potato over to the landlord and tenant board, where it's a struggle to answer the question. But assuming the landlord and tenant board finds, yes, vacant possession is required for this work, it's extensive enough, then does the landlord actually intend to do it? The landlord at this point can only just promise, yes, I do intend to do it. They don't seem like they're lying. Then the landlord and tenant board looks at discretionary relief and mandatory relief, which we don't need to get into in detail, but it's a further opportunity for the tenant to say, hey, there's an ulterior motive here. Like this application suspiciously aligns with me complaining about some maintenance problems for the first time in 10 years. And then all of a sudden, I'm getting hit with this eviction or me refusing an illegal rent increase, right? Those are often the grounds that get raised. Assuming the board doesn't find any evidence of that, the eviction order is granted. And then the legislation says that the tenant, before they move out, whether they're moving out voluntarily earlier in this process or later as a result of an eviction order, they just have to serve the landlord with a notice that says, I intend to exercise my right of first refusal. That means, in plainer English, that when the work is done, the landlord has to let the tenant know, and the tenant then has the right to move back into the newly renovated unit at their old rent, at the rent that they had been previously paying. And it's like they pick up where they left off in terms of their tenancy. This hopefully should start the wheels turning, right? So we're saying, okay, no fault evictions, they're this really risky thing for tenants because potentially landlords have a big incentive to bring those applications in bad faith. It's a chance to get the tenant out without having to prove the tenant's done anything wrong. And here, there's this big letdown for a profit-seeking landlord at the end. Womp womp, like you did all this work, you spent all this money, you upgraded the unit, and the tenant gets to move back in at the old rent. You're not going to make any more money. So bad faith rent evictions actually take a few forms, right? One form is the landlord brings the application and then doesn't do the work. They just turn around and re-rent the unit to somebody for twice as much money. The other more notorious example has happened a number of times, but perhaps the most high-profile case was 795 College, because those tenants were some of the actresses on CBC's Baroness von Sketch show. I don't know if any fans of that show, but let's say they had an easier time conversing with the media about what was happening to them. They got an N13 notice. They didn't believe that the landlord for a second was planning to honor the right of first refusal. They thought, yeah, the landlord's going to do the work. They're going to upgrade the unit, but they're going to turn around and rent it to somebody else. And they said so. The board said, nope, we're evicting you anyway. We have to believe the landlord in this case. And the landlord did the work. The landlord did not tell the tenants that the work was done. And by the time the tenants discovered that the work was done, they met the new tenants who had been re-rented the building that was newly renovated at about double the rent. And they tried to bring applications saying, you should kick those new tenants out and let us move back in at our old rent. Landlord and tenant board said, but we can't do that. Once there's new tenants in, they have a right to be there. All we can do is compensate you. And the case wound its way through a number of legal processes covered in the Toronto Star and the CBC and elsewhere. And what was notable each time is that no matter what degree of compensation was awarded to the tenants, or no matter what fines the landlord faced, and the landlord was charged and fined by the province, it was pretty easy to see that after a couple of years, the landlord was going to have come out ahead, right? That the extra rent that they were able to charge could fund all of the compensation and all of the fines, and it was still ultimately a good economic move for the landlord. And a lot of those fines and those just monetary compensation amounts were the cost of doing business. From the tenant's perspective, rent increases are forever, right? And I mean, no tenant knows how long they're going to be in their apartment. I've met many tenants in Toronto who've been in their apartments since the 80s. People can potentially live a long and prosperous life, I guess, in one apartment. And if you all of a sudden have your rent increased by $1,000 or $2,000 a month permanently, then it's difficult to actually calculate or to know how much rent you've lost, how much your damages are. They just keep piling up every year that you could have been paying your lower controlled rent, but instead you're paying some higher rent because you were forced to move in a manner that is prohibited by law. So that's kind of should add to kind of the context that we're facing here, and should help us then identify why tenant advocates, and particularly tenant organizers, the group ACORN Canada, so the national tenant organizing group, has really pushed for municipalities to tighten up their rules for when they issue building permits for renovations. Because remember, the Landlord and Tenant Board requires that the landlords obtain building permits, and ostensibly until now, the city's building department or the local municipality's building department is only thinking, does the proposed work comply with the building code? Does the proposed work comply with our zoning bylaw and our local bylaws? Just a purely technical exercise. And there's not really been this authority for municipalities to think about, okay, but is this good and is this suspicious, right? Like from a tenant perspective. So that requirement that the province has in the landlord tenant board is a kind of hook, right? That these municipal bylaws grab onto and then start to do a lot more that's responsive to the concerns that tenants have raised. Okay, so in broad strokes, we're describing, I think, what we'll see in all of these renoviction bylaws. They are rather template form, and it's for a reason, because it's a model that was first adopted in New Westminster, and sometimes you hear it referred to as the New Westminster bylaw. These will say, okay, before a landlord can get a building permit that would require a tenant to move out, or that is part or connected to an N13 eviction process, they have to, there's a sort of requirements about their communication with tenants. Certain notices need to be posted. Information packages have to be handed out that provide tenants with more information about what's going on, what the proposed work is, what their rights are under the bylaw. And that communication is enforced through the building process, right? Regular updates. In Toronto's case, a searchable database where tenants are able to monitor and track from the municipality's perspective the landlord's process or the proponent's progress on the work that they're getting done. So the tenants aren't left in the dark wondering, is the work done? When am I going to get my right of first refusal? Has the landlord already moved new tenants in and leaving me kind of skunked, right? for lack of a technical term. And then enhanced certainty as to the vacant possession requirement. Again, that's what we're going to focus on, because that's the feature that involves architects and engineers. Enhanced compensation. So really moving from here's 1 month's rent, here's 3 months of your rent. And by the way, under that model, the provincial model, the lower your rent is, the less compensation you get. Well, how is that related to what you're going to end up paying to move or paying to rent somewhere else temporarily while you're out of the unit? It's not related, actually. It's inversely related. So the bylaw comes in and says, no, here's a much larger amount that needs to be paid for tenants to compensate for their moving expenses. And here's a rent gap amount that needs to be paid for tenants, unless the landlord is able to provide the tenant with alternative accommodations that the tenant is willing to move into. I mean, that's always there. That's there in the provincial process. That's there in the bylaw. It hardly ever happens. So instead, there's this formula that I'll use the Toronto bylaw as an example, looks at average rents since 2015 for that size of rental unit, because that's a stat that's tracked by the federal government locally in this census area, and then measures the difference between that and the monthly rent that the tenant had been paying. And that's what the landlord has to cover, because it's meant to be an estimate of the extra expense or the extra cost that the tenant is going to be paying temporarily while they're out of the unit waiting for the repairs to be done. And then additional monitoring, which kind of ties into that enhanced communication piece, that is all meant to prevent the landlord from ever closing the building permit and re-renting to somebody else without offering the right of first refusal. So within this scheme, first of all, we should say it makes it less likely that landlords, by and large, are going to apply for renoviction evictions or renovation evictions because of all these extra requirements and extra costs that are being transferred from what the tenant was paying to what the landlord will now be paying. But when it does happen, it happens with quite a bit more municipal involvement. And it turns out engineer or architect involvement. Just zooming in on a couple sample bylaws, we have this concept of the qualified person. So every municipality will look at this and say, okay, we're being asked by Acorn to do something to make extra sure that vacant possession really is required, that this isn't just cosmetic work that the tenant really could live through. And in each case that I'm aware of, the municipalities said, well, we're not answering that question. Let's find some qualified professional who can answer that question. And consistently in Hamilton and Toronto and London so far, the qualified professionals are engineers and architects. And they're required, so you would be required, if asked, as part of a landlord's application for a license under this bylaw, to provide a report or a letter explaining how it is that the work requires vacant possession. Vacant possession meaning the tenant's got to move out. This can't be done while the tenant is living there. Okay, so I think now we'll maybe turn back to polls 2 and 3, if that's okay, to just get a sense of, I don't know, how you would answer this question, or what you would use to answer these questions. All right, excited to see the results. Okay, so again, a real interesting split or division between those who feel that their experience and expertise, their knowledge as an architect equips them to answer some of these questions, or not, or unsure. And I mean, I don't think there's a wrong answer to these questions, to be clear. It seems to me that the diversity of architecture and frankly engineering practice probably means that not all of the licensed professionals under either of those professions are going to necessarily be equipped to answer these questions, to answer the questions that the bylaw entitles them to answer. So, I mean, it would be my first suggestion, although obviously you should defer to the OAA and to your insurer, is that you got to first know whether you're the type of architect who should be answering this question, who should be providing this report when being approached, or if you're approached and asked to provide one. That's a first question. And then the other kind of observation that I think I might make at this point is in speaking anecdotally to a couple of family members who are retired architects and to your colleagues here on the OAA, the form of the question, is vacant possession required? Yeah, it might involve questions about noise, dust, impacts on bystanders, or safety, but in a kind of different or reverse way than what you might typically be asked to do in project management. So just thinking hypothetically, I mean, if you are in your practice are overseeing or involved in residential renovation work, and you're thinking about safety and safety risks and danger, you're presumably thinking about ways to ensure that that the work is done in a more safe manner, or in a manner that minimizes impacts on bystanders. And that is kind of one direction, right, for your thinking. It's a good direction, right? Like, no doubt. But the question that the proponent might be asking under this bylaw that helps them actually get their renoviction, if that's what they're looking for, kind of runs in the opposite direction, right? You're being asked to say, is the work going to cause a lot of danger? Is the work going to cause a lot of interference or a lot of impact on bystanders? Say yes, right? I think is the concern that we have here. And so thinking about not whether there are more safe ways to do the work, but actually whether or not the work, whether it's unavoidable that the work is going to be dangerous and cause harm to bystanders, is a different kind of angle on some of that expertise, I think. Okay, but no doubt those of you who get into this and get some experience providing these reports are going to develop that expertise further. I think that's kind of what I would expect to happen. Okay, so we will just say in detail, Hamilton and London just would expect you to prepare a letter or report, not only outlining the proposed work, but then explaining why vacant possession is required. Toronto has you put it in a form, but you could attach pages as you wish, and you'll see there's an attestation or declaration at the end of the form. You are certifying, first of all, that you are a qualified person, right, but within the meaning of the bylaw, so you are licensed, and that the report's accurate, and of course that kind of overlaps with your professional obligations anyway, right? As we'll discuss, and as all of you know, like when you're a professional, as a professional engineer, you can't really be providing false or misleading information in the course of your practice to anyone, least of all a government authority. So maybe this is a little bit redundant, but it drives the point home that the City of Toronto wants the whole truth and nothing but the truth, so to speak. I think then we should just clarify and make sure we're on the same page about what vacant possession is required means. What does vacant possession mean? Okay, so it's a factual question. And I should note that these multi-stage, multi-level of government processes could mean that if you answer the question once, you might be called upon to answer it again or answer questions about it, right? So in an hypothetical renoviction process, if as an engineer you provide a qualified persons report to help the landlord obtain a renoviction bylaw license, then the landlord's going to be able to proceed to serve the N13. And if the tenant doesn't voluntarily move out and the landlord applies to the landlord-tenant board, well, now the landlord has to basically prove the same point again, but to the satisfaction of the landlord and tenant board. So the landlord and tenant board, we might expect them to receive a copy of your report in a case between the landlord and the tenant, where the landlord is saying, well, I have great evidence on this point that vacant possession is required. I hired an architect and they prepared this report. And then the tenant might be able to summons you to testify about that report and might be able to ask you questions about that report. So you'll be providing potentially evidence under oath, or your report should be considered evidence under oath. That I think then, for those of us who are litigators, we would call that expert evidence, right? You'd be essentially acting as an expert, and there your professional opinion is fact, right? It's something that you're allowed to do that other witnesses might not. So I think that's the level of detail and certainty that you should, and independence really, that you should approach letters and reports of this type with. I think required, I would argue, and if I'm ever cross-examining any of you at the landlord and tenant board, here's the sort of heads up, right? I'm going to say required probably means more than, well, this would be the most convenient way to do the work, or this would be the cheapest way to do the work, as if we could just get the tenant to move out. Required, as a word, like, it communicates intent both in the provincial legislation and the bylaw, that maybe not impossibility, but I mean this sort of idea that it would be very impractical to get the work done while the tenant is also living there. immediately calls to mind that question I asked at the beginning of this talk, right? Which is, if this was an owner occupier getting work done inside their own home, would they need to move out? And I would suggest it really depends on the homeowner, right? And that's where this might go beyond your expertise. I think the question you're being asked to answer doesn't turn on the tenant's personal appetites or or flexibility. You have to think about, just in very general terms, regardless of who the tenant is vacant possession required? And I think it would be appropriate to acknowledge where, in a report of this sort, where a tenant might be able to live with this if, depending on who they are, right? And just maybe speak to the level of interference or of safety risk that a tenant would be asked to live with if they stayed in the apartment. The Toronto bylaw also seems to distinguish between the extensiveness or the extensivity of the work and whether or not it presents a danger to health and safety, which suggests that there's other things, right? And I would suggest the other things would be just being able to get the work done while a person is living there. So to me, when we're thinking through this, we're going through this exercise and trying to understand, okay, well, what is vacant possession and when is it required? We should also talk about, like, what exactly is the matrix of tenant rights when they don't give vacant possession, when they continue to live in a unit and work is being done. So if the tenant is in possession, they're continuing, they're not moving out, they're not being evicted, and the work is getting done, landlord has to give 24 hours notice before entering to do the work. Should be hopefully possible, right? Like, it's difficult to imagine work that you can't plan the day before to do, whether you're doing it or not. And then there's a further kind of regulation that's longstanding under the tenant regulation that effectively deals with whether or not tenants can be compensated by landlords for interference caused by work that landlords are doing either inside the unit or inside the building. And I guess, short gloss on this regulation is that there's a list of things that if they apply, like there's a list of types of work that I've put on the slide that presumptively mean a tenant is getting no compensation. A landlord can just do that work. It can make the tenant's life temporarily difficult while they're living there. It can even involve disruptions of heat and water. And what the regulation keeps going back to is reasonable. Is it reasonable in the circumstances? Was the degree of interference more than what might be reasonably expected given the work that was being done? So, I mean, there's even this suggestion that really extensive work, or the more extensive the work, the more of a pain it can be for the tenant without them even getting any compensation, or let alone any ability to stop the work. So that's confusing too when we start to really delve into this idea of vacant possession being required. It's like, well, are we really, I mean, can't the landlord just go ahead and do this and the tenant's just got to put up with it? The possible cost to the landlord in terms of compensating the tenant doesn't really appear to be there in many cases, unless the work is done in a very careless fashion, right? Unless the work is done in the middle of the night, or is done, without appropriate safety measures that would be standard for that type of work. And that's again kind of loops back to, well, if an architect's involved, presumably everything's being done in the way that is most protective of safety for bystanders and of effects on bystanders. The tenant has to cooperate, right? Is this idea. Not only do they have to put up with it without compensation. So the lead case on that is a case called Anisku, where elevator work led to tenants, and some of them tenants who had physical mobility restrictions in a Kingston building, not being able to get up to their apartments on above the first floor for a large part of a 10-month period, and they couldn't get any compensation. It was found that, well, the landlord did their best, and that's, you just deal with it. Work had to be done. So, I mean, it's really hammered home this idea, the regulation restricting what tenants can get, and this idea that when landlords doing work and the tenants are living there, they have to put up with it. I mean, I think is the big message from that the legislation provides. There's also a number of cases, I've just picked one kind of at random, where landlords are doing certain kind of work, and unfortunately often it's pest control work, and if the tenant gets in the way, if the tenant doesn't move their belongings out of the way or pack up or prepare their unit in the way that's instructed by the landlord or the landlord's contractor, the tenant can actually be evicted. And that'd be a fault-based eviction. So when we're thinking about, well, there's some work, but the tenant is going to have to temporarily clear out of the unit, like with bed bug spray, the tenant has to be out of the unit for a number of hours, their occupants, their pets, because it's toxic, right? I mean, that doesn't involve eviction unless the tenant refuses, and then they got to go, and they're not getting a right of first refusal. Same with moving belongings, packaging up belongings to allow landlords to do painting or floor refinishing. Like, there's a number of things that routinely require, like routine maintenance that requires tenants to move and shuffle around and be temporarily absent for even a few days without their tenancy coming to an end. So we're probably talking, when we're talking about extensive renovations that require vacant possession, I think this context helps us understand that it better be taking place over a long or protracted period of time that just goes beyond what you would expect a tenant to be able to work around or move around or be temporarily absent to accommodate. Ending with professional considerations. Okay, so your code of ethics is admirably short. Very jealous as a lawyer that this is how short your code of ethics is. I mean, I think it hits all the high points. And I've just selected a few that I think are engaged here by this question, because the thing I, as a tenant advocate, want qualified professionals to have front of mind when approached by landlords seeking a qualified person's report or letter is, am I being sucked into a scheme intended to evict a tenant in bad faith, either because the work isn't really going to happen, or in the more common case, the work is going to happen and then the unit's going to be re-rented to somebody else. A risk, unfortunately, that still exists despite all these additional protections under the municipal bylaw, the Renovictions Bylaw. It goes a long way to preventing them and to making it just a lot more of an expensive exercise. But the municipality, at the end of the day, like the province, doesn't think it has the legal authority to remove a new tenant who's paying a double rent, right? That just doesn't seem to be on the books at this point. So, so keeping that risk in mind, I think, and understanding the history and context and the legal system surrounding that risk, and the really understanding that this qualified persons requirement is part of a set of tenant protections that have been adopted to try to combat bad faith evictions is pretty critical to understanding your own role, right? And why we want architects and engineers to weigh in as opposed to contractors doing the work. Like, there's an expectation that professionals will be able to manage the interests of the public and keep those front of mind as opposed to just the person who's hiring them, right? Which I'm sure is the kind of thing you must hear all the time from the OAA. Looking then at the regulations under the Architects Act, I think there's a little bit more detail about specific examples of a behavior that would not only fall short of the OAA Code of Ethics, but also be a specific instance of professional misconduct that would attract the kind of penalties described in the regulation. So, of course, knowingly contravening any federal, provincial, or municipal law or regulation, authorizing, permitting, counseling, assisting, aiding. I mean, they've come up with all the synonyms here, right? If you're involved in a process that was ultimately a bad faith eviction, among other things, it's a real professional risk, I would suggest. You know, again, just acknowledging my perspective as a tenant advocate. Then, you know, more pointedly and obviously, it's professional misconduct to sign or issue a false or misleading certificate, report, or other document that puts you in I would suggest a difficult position when you think about how much detail and how many hypotheticals to explore when giving a qualified person's report. I mean, do you get to leave anything out that's pertinent? I don't think so. I wouldn't suggest it. Doing or failing to do anything while engaged in practice of architecture that shows a deliberate or reckless disregard for the rights or safety of others. And returning to my comments near the beginning of this presentation, a tenant that has to move, I mean, obviously, allowing work to proceed or being part of work that's proceeding, that's putting the tenant at risk because they're not moving out, that's a more conventional concern. And it's good that we have professionals who are required to guard against that. But it should, make no mistake, like there's not a ready supply of affordable housing for tenants to move out into when evicted, when rent evicted. So a person's safety and a person's well-being is at issue whether or not they're moving out potentially. And if they're moving out, that's a particular kind of risk or concern that you're just being asked not to show deliberate or reckless disregard for. And it would be a subject of a whole other presentation to discuss, okay, like what are the risks involved in rent eviction or in eviction generally? I'll just say, by way of quick summary, that homelessness, for example, is now widely understood by Canadian medical professionals to be one of the greatest sources of all cause mortality. It is something that cuts your life expectancy in half by the very least. It's the kind of thing that leads to all manner of disease and other aspects of declining health. It's we could debate whether we might call homelessness a death sentence, but it gets there. It gets towards that kind of zone of risk. And I think that this is not something that's necessarily well acknowledged in municipal and provincial processes involved in eviction. But as professionals, we can at least be aware of the facts surrounding it and the risks that the life-changing risks that are attendant to bad faith eviction, or any eviction for that matter. Thinking back to, okay, well, what kind of laws might be breached if I gave a qualified person's report that turned out to be false or misleading, or at least part of a larger attempt to evict a tenant in bad faith? Well, certainly the Renovictions Bylaws themselves create a number of offenses for any person who, well, you've got the sort of the list here: knowingly makes, participates in, assents to, or acquiesces in the provision of false information, a statement, affidavit, yada, yada, yada. And skipping to the end of the Renovictions Bylaw in Toronto, the City of Toronto is actually not only has bylaw offense penalties that will be $10,000 for individuals and up to $100,000 for corporations, but the city also has the ability to increase those bylaws. They have the authority under the City of Toronto Act to increase bylaw penalties to whatever amount of profit has been made or revenue has been made from the breach of the bylaw. So difficult to come out ahead if these are properly prosecuted from the perspective of the offending party. The Residential Tenancies Act, of course, also contains a number of offenses not often prosecuted, but they're there just the same, and I think they're tied into your own misconduct requirements. Really anything that harasses, threatens, or coerces a tenant to move out, or tries to scare a tenant into moving out, obtains improper permission by giving a notice to terminate a tenancy by giving a notice in bad faith, furnishes false or misleading information to the board. And remember my comment that you give a report to a municipality, it's very likely then to be submitted to the landlord and tenant board as well. So potentially offenses on top of offenses and fines on top of fines, but in many cases that doesn't ever quite put things back together for the tenant that's been kicked out of their home wrongfully. Anyway, that I think is as far as I got in thinking through this problem, and hopefully we have time for some questions.
Thank you so much, Ben. That was such a thorough review, and the way you weave together the complex legislative framework into the Architects Act is fantastic. And I don't know for those of any people on the call who have questions now, put them in. But I want to just tie it back to, we did a webinar a few weeks ago on the complaints process and professional misconduct. And so the sections that you highlighted, it's so important. I think one of the reasons why, as you pointed out, engineers and architects who have requirements for professional conduct are chosen is because you're right. It's the framework of a professionally regulated or a regulated profession. Is the duty is to the public and the public input. So I have such a richer understanding of all of the details of this piece of legislation, and I'm hoping those people who are on the call were potentially asked. And this is new legislation, right, Ben? It was like, can you remind us like a little bit of the timeline and maybe tell us, have you seen this being used yet? Is there anything bubbling up? And should we invite you a year back from now? This is going. What's the word on the street for this new
So yeah, thanks, Claire. I probably, you know, we said this in the lead up to the presentation. There might not be as much, have been as much attendance, but there is reason to really question whether or not, like, how many instances of renoviction licenses will actually be issued at the end of the day. This is something that the City of Toronto really struggled with in its consultations in the lead up to the adoption of this bylaw. So to answer the question about timing, I believe Hamilton adopted their version of the bylaw last year. The City of Toronto and the City of London both adopted in 2025, and the City of Toronto's bylaw took effect in summer. I believe it was in July of this year. And two quick observations just locally. Our clinic and other legal clinics saw an uptick in renovictions just before the bylaw took effect. So a number of proponents serving N13s in the week leading up to the bylaw taking effect, on the understanding that, you know, they weren't going to have the bylaw requirements apply to them. So, you know, it's at least some kind of message about, okay, the bylaw does something that that does make a difference. The Advocacy Centre for Tenants Ontario, which operates the Tenant Duty Council program, has an opportunity to track the questions or the types of cases and types of requests for legal advice that they get from tenants, from self-represented tenants over time in a much higher volume than any individual legal clinic. And they reported that after the City of Toronto bylaw took effect, questions about renoviction applications from tenants went to nearly zero. There was a dramatic drop off. So there's some early anecdotal evidence. I don't think we're quite at the point of being able to track this in a conclusive way, that the bylaw has made it so that far fewer evictions of this sort will be attempted. Now, in my own view, and the view that I and some of my colleagues shared with the city, that maybe is the point, right? Like, if we think that the problem with renovictions is that to date, there's just been a lot more exaggeration of the need for vacant possession, and that a lot of work can be done with the tenant still living there, or maybe doesn't need to be done if until the tenant eventually moves out, because like you're doing these renovations, and unless the renovation is required to like restore the physical integrity of the building or deal with some kind of emerging risk, you know, sort of upgrades to buildings don't actually make much sense if the landlord has no immediate expectation of being able to re-rent. So, you know, having the city asked, like, how can we make this bylaw more user friendly? How can we ensure that that landlords are able to work with it easily? And, you know, I think my response at one point was, you know, no, that, like, actually the goal here is for it to be difficult, or for a landlord that's really willing to go through all of these steps spend all this money, hire these professionals. I mean, that was the debate about qualified persons, right? Is that a number of landlords complained, and it's a complaint I'm sure many of the people on this webinar will be familiar with. I shouldn't have to pay an architect for this. Like, and that this is, you're making this, you know, my redo of the kitchen just so much more expensive. And, you know, but I think the proper answer is like, well, look at the cost the tenant is going to have to experience. Even if you follow the law perfectly, it's just not cheap to move, find another place for an unspecified amount of time, and then eventually move back in. You know, landlords really have to match that kind of energy, I think, is the idea, right? Like, so if the work is really, really that necessary, it'll be worth potentially the expenditure and the complexity of this process. But for many, I don't think it is, and I don't think it will be. So I think there'll be just a lot fewer of these. But when they happen, it'll be an architect or an engineer who's pulled into the process.
Mhm. Right. And like you said, the problem is the bad faith evictions. And so if that's what the legislation or the bylaw is doing, then it's targeting the issue.
Yeah.
And it ties into nicely to what we talked about with our chair of the complaints committee, Tom Dreesen, for those of you on the call who are there. A lot of times architects are kind of pressured to sign documents, like we call it rubber stamping in the architecture profession. And what we say is it's the role of a professional to really educate the client on what the value is that you're bringing to the project. You're not just stamping something willy-nilly, you're bringing all of this years of experience and professionalism. I know that we had one question where the second poll they couldn't see. I don't know if that was resolved by Sharika posting it a little bit later, but when I looked at it, it looked like about half of the audience really felt comfortable advising on this. And then there were a few people who maybe weren't in the area, so it's hard to know if it's 50-50, but it's good to see that a lot of the participants feel comfortable in being in that position. And hopefully we should have done a poll, maybe in the survey at the end, we can ask how people feel after hearing Ben's webinar today. I certainly think there's a much clearer basis and just looking at the case law in general. Okay, so we do have a couple of questions. I'm going to go to this first one here. It says, is there a definition on what type of engineer could be a qualified person?
Yeah, so in the 3 versions of the Ontario bylaw that I've read, in Hamilton, Toronto, and London, no, it's just a professional engineer. In one of those bylaws, they say a professional engineer or another acceptable qualified person, which leaves then the city's chief building official to immediately designate architects, but then have the option to eventually designate others. But no, it's very broad at this point, and I suspect engineers will have would need to have the same kind of split and concern as we worked out through the poll, where, you know, some engineers, I have a friend who's a robotics engineer, there's no way he should ever be signing one of these reports, and he would know that, presumably.
Yeah. And that's also part of one's professional obligations. Like Ben and I are both lawyers, but I'm certainly never going to do real estate law, all right? Because I'm not competent to it. And so part of your professional obligation is to only take on jobs, tasks, projects that you're competent to do. And as a professional, that's within your discretion. Okay, so there's a couple of other questions. Really good one. Is there anything that can help those who've already experienced renovation? Probably not architects, but maybe certainly Ben.
Well, right. Just speaking more generally. So we should also say that in Toronto, I don't know anybody about anywhere else, but the related no-fault eviction of demolition is something that for a number of years in larger buildings in Toronto has been subject to a kind of similar municipal framework where, you know, if you were just going with the provincial process, if you were in a small town or outside of Toronto, you get your 1 or 3 months compensation and that's it. And there's no unit to move back into. There's no right of first refusal because it's being demolished. The City of Toronto has a demolition control bylaw that they've had for a number of years that says they're not going to approve a demolition that is almost always in Toronto connected to a redevelopment unless the landlord provides a rehousing plan, extra compensation for move out, extra notice, a rent gap payment, and ultimately a unit at an affordable or similar old rent in the new project when it's finished. So this, I guess that's the first thing I'll say, is that we've learned a lot about what we might expect from the city's involvement in renovictions from the operation of their demolition control bylaw. And what we'll say is that it's been night and day difference, right? With renovictions, no one had heard of anyone, practically speaking, ever getting the right of first refusal honored when landlords were on their own with the provincial process, because after the landlord tenant board makes an order, they're done with the process. And it's on the tenant within 1 year of moving out to file an application that a landlord gave eviction in bad faith. That's what happened in the 795 College case that we talked about, and it turns out that all that's on offer for tenants is compensation, up to 1 year of rent differential, and then, but of course the effects of this last much longer than 1 year. So that's why the compensation and the fines are thought to be inadequate in a no fault, in a bad faith eviction application. Meanwhile, for anyone subject to the N13 for demolition, where the city's bylaw was engaged, they're having a very different experience. They have a contact at the city. First of all, their local city councilor is drawn in and made aware. The city's building department then has this contact that the tenants can make to say, okay, how are things going? Like, they're getting regular monthly payments, right, from the landlord being enforced by the city for that rent gap payment. And so each month is a little update, right, a monetary update anyway, on how things are going. And that is just completely different than the sort of left in the dark, I don't know when this work is going to be finished thing that tenants face. So the involvement of the city, by its very nature, for anybody who's gone through permitted work, you have an ongoing relationship with the building department until the work is completed. You have inspections, and so that's why it's thought to be appropriate that the city also, while they're at it, maintain that kind of connection and that information flow with tenants. So I think those have all, but if we're asking those who've already experienced renoviction, I would think, those would be under the old pre-bylaw regime, let's assume. Yeah, all that anyone who can do when they go through renoviction is, if they've given a right of first or a notice of their intent to exercise the right of first refusal, and they suspect that the landlord hasn't honored it, it's a T5 application. There's still, I would say, a little bit unsettled law as to whether or not it's possible to put tenants back into possession through an order of the landlord and tenant board. It would be presumably a lot easier, we think, if a tenant managed to get litigating against the landlord before a new tenant has moved in,
Right.
because then there's not the rights of some third party at risk. So I don't know, this is almost like silly to say because I don't know how you'd pull it off, but a tenant that gathers evidence that it looks like the work is done, but I haven't been notified and I haven't been given an opportunity to move back in, if the tenant could somehow file a T5 application, the landlord gave notice in bad faith, and ask for an immediate order and an urgent hearing ordering the landlord to put them back into possession, and can somehow get to a hearing and get that order all before the landlord re-rents to another person, maybe, right? Maybe you're getting back in. But among tenants, they really understand that ability to move back in at your old rent is worth just sometimes infinitely more than any monetary compensation one time that a tenant can get. So pretty tough gauntlet to run from a litigation perspective, especially with the landlord and tenant board having hearing delays for tenant applications of up to a year, right? Is the status quo right now. So there's not a lot of options.
Yeah. There's so many moving parts with that too. Okay, there's a new question that just came in. There was a question that was a little bit off the topic around rent control for newer buildings.
I could quickly address that, yeah, and then get to this next question. So shedding light on new buildings constructed after 2018 not being rent control. Yeah, it's an exemption At one time it was anything built after 1991, and then it was anything built after 1998. And then in 2017, the province said, no, it's just everybody's covered by like in situ or in tenancy rent control. And then in 2018, the very next year, they said, nope, all new buildings. So this was part of a political debate and economic debate about whether or not rent control is a disincentive to new rental housing construction or not. But the longer these new construction exemptions are in place, the bigger and bigger chunk of our housing supply is covered by them. And I would just say, without rent control, much like without security of tenure, there's a lot less to do, and there's a lot less options, practically speaking, to protect tenant rights in those properties. It just doesn't make sense, for example, to bring an application against a landlord about a maintenance or harassment problem or disputing a rent problem if they can get back whatever you win on their next rent increase, right? That this sort of, so you could think about a spectrum of housing from Airbnb on the very temporary end to traditional like pre-1970s rental stock in Toronto on the kind of longer term end. And how we treat that stock is a political question, right? Like do we expect tenants to just move around constantly? Do we think about rental as a temporary stop on the way to home ownership, or is it something that for some people is a multi-generational, just like permanent way that they have any shelter or housing at all? I mean, these are big political questions that probably go beyond the scope of what we can discuss here, and much as I'd like to.
Absolutely. I know, yeah. And then the final question actually kind of tackles or points out some of the why, like why would a professional even agree to this? And the question around, does Prodemnity have an opinion? So we did check in, but Prodemnity is aware of the bylaw. Not that I'm aware, there's no official position from Prodemnity. It could be like sometimes when you have a new bylaw or piece of regulation, it can take some time before the issues come to the surface. Certainly Ben's raised all of those concerns and considerations for professionals. Should you be approached, we would, invite anybody. We do have a practice advisory hotline with the OAA. The OAA can never give you legal advice, right? We can't tell you whether to do something or not. It's more about building awareness, and I hope that this presentation and Ben's all of his extensive knowledge on the issue will give you that insight. I mean, it's a question of, I'm kind of answering the question, but it's really a question of risk, right? You're deciding to take any project on, there's always going to be risk associated with it. So, yeah, I think the why is really going to fall back. I don't know, Ben, if you had any thoughts on.
Yeah, well, I have a couple. One is that I come to this presentation with some degree of sympathy for architects and engineers, because I've used the phrase hot potato. Like there are a number of different sort of government and quasi-judicial decision makers who struggle with answering this question of whether vacant possession is required. And so to just kind of dump it on professionals who may or may not have asked to play that role, or may or may not have traditionally played that role, is that's a tough one. And it's the kind of thing where in its infancy, we would maybe expect or hope that Prodemnity, as well as perhaps the OAA and the PEO, would over time maybe be able to develop guidance for architects, as well as architecture education programs, like degree programs, would begin to start thinking about, okay, like what's our framework for answering this question for when vacant possession is required or not. I mean, that's at least how the law would approach something like this, right? We build up a test, we think of examples, and we think about, okay, what are the factors that you want to be thinking of? And I've started to vaguely reach for those things, right? Well, it's maybe about safety or noise or dust or like, but time will tell, examples will tell, I think, whether how we get to the answer to this question. But to this idea that, well, why would you ever do this? Yeah, I mean, most lawyers are going to tell you, like, it's safer to not do this, like safer to just stay out of it. I mean, it's not a helpful thing that lawyers often say. It's just like, just don't do anything. That's the lowest risk approach. But I will say that, like, to this point about degrading rental stock, that's exactly the same argument, as it happens, that justifies that has been used to justify the limit on tenant compensation for the effects of work when they do stay in their unit, right? Like, it's the idea that, well, if we have to compensate tenants, we're just not going to repair any of these units, and all the housing stock will fall into disrepair. You know, so the answer to that is, hey, good news. If landlords want to improve or maintain their rental stock, they very often can do so at the expense of the tenant in terms of living through it, right? And in terms of receiving temporarily much less than what they're paying for, whether it's a working elevator or a balcony or peace and quiet or privacy, right? Like, there are any number of things that over time our province has allowed landlords to do and has excused landlords from having to compensate tenants for that. So we really should only be talking about the kind of degrading housing stock that, where housing stock degrades as a result of not doing work that you just can't possibly do while the tenant's living there. That's the question to be answered, right? If you can answer that question, here's the work where we just can't do it with the tenant living there. Well, then you're being called upon to say, in the cases where that work is proposed, tenant's got to move out. And then, I think some solace that I'd offer to tenants or say to tenants is they're now, if they're subject to that eviction, they're now at much lower risk of being denied or their right of first refusal, and they're at much better positioned in terms of the amount of compensation that they're being that they would be paid under this licensing regime. So I don't mean to overemphasize, although I think this is something lawyers also do. I don't mean to overemphasize the risks. There obviously must be some cases where your opinion could be, yes, vacant possession is required, and where where presumably, if the landlord that you're working with is abiding by the law and by their legal obligations, the tenant's going to get back in, and most of the costs of being out are going to be borne by the proponent.
Mhm. Well, as we said, it's definitely an evolving issue, and we at the OAA will be monitoring it and perhaps inviting you back for a year in review to see how this goes. And I'm really fascinated, but I do think, yeah, it's good to understand the whole history of this framework. Yeah, it's great to have your expertise and your knowledge and bringing such a clear path. So before we're almost at time, we have 2 minutes left. I just have a couple of announcements before we close off. Thanks again, and thanks for the great questions as well. We do have a webinar coming up next week called Being the Consultant under the Revised Construction Act. So again, a really good topic and another legal lens. So if you haven't already, I would encourage you to look at that. We will be reporting your content, as I noted. Just give us a few weeks, maybe a little bit more patience is required when we've got a busy time of year right now, specifically around content uploading. So have some patience, please. And then we do include these slides and a link for a survey. So really important. We love specifically this topic. We would love to hear from you. Was this information valuable to you? Is this something that we're considering doing, involving in renovation? So thanks again, everybody, and please have a pleasant remainder of your day. Bye-bye.